So in California, we have what we call assault and battery. Battery is the mere touching a person in an offensive manner is sufficient to establish a battery. An assault requires more of an egregious act of touching or injuring a person. So for what would constitute an offensive touching? I go ahead and put my hands on your shoulders. I'm not necessarily causing injury to you, but it's offensive to you if we're in an argument. So that would be enough for a battery. For egregious touching or an egregious act, it does not require that you utilize any weapons. So your hands are sufficient, or any extension of your body is sufficient for the crime to be committed. Out of the two, between assault and battery, battery is the least when we talk about physical contact. If the contact becomes a little more aggressive, more damaging to the other party, then we enter the realm of an assault. So the penalties for assault in California depend on the egregiousness of the act and the consequences of the injuries. We can have a misdemeanor assault, which you have maximum sentence of 1 year in county, or you can have assault with great bodily injury, whereby you're looking at a felony and you're looking at state prison. As to the commonality of assault and battery, I think they're about equally common, and so long as they're misdemeanors, maximum that they can receive in California is 1 year. So I think the most common misconception with regards to assault and battery is how much of a contact is sufficient. A mere offensive touching of a person is sufficient to carry out a battery charge. So minimal touching that's offensive to the other party is sufficient for that. So misconception is it requires that you beat up a person. No, a mere offensive touching will be sufficient. Most of the time when you're trying to determine what is the evidence in an assault and battery case, a lot of it will be the word of the victim against the word of the defendant. And so as a criminal defense attorney, in preparation for perhaps trial on this matter, if the person decides that they don't want to negotiate a resolution, is to look to see if the person has any contradictory statements, if they're in their life, there have been instances where they have, for example, lied under oath. And so we can use that to say, well, if the person has done this in the past, it's more likely that they're lying in this case. And that would be to diminish the credibility of their testimony. Circumstances that differentiate an assault and battery charge. Two people arguing out in the street. They start pushing each other. Have they really caused damage to the other party? No. Have they offensively touched the person? Yes. That's sufficient for a battery. Now, the argument escalates. Now we're not just shoving each other, but we're actually punching. Blood is drawn. Say you punch to the nose starts bleeding. Then you start looking into an assault charge rather than a battery charge. So as to the maximum commitment, if they're both charged as misdemeanors, again, it's a maximum of 1 year on either or. It's just the egregiousness of the act that differentiates between one charge versus the other. So if you're facing charges for assault and battery, I invite you to contact Confianza Legal for your free consultation.